All right, let's see if we can get this webinar started. My name is Carol Levine, and I have the honor and privilege of being the chair of Courts Matter Illinois. And I want to start by giving you a disclaimer. I am not a lawyer. I'm a community organizer and a longtime advocate, and came to Courts Matter Illinois because of those things. So let me start by giving you all a few housekeeping items. All of your microphones are turned off, as are your cameras. You'll be able to see all of our speakers and hear them, but they will not be able to see you. We are asking that you put any of your comments in the chat box, which can be found at the bottom of your screen. You can just click on that item that's marked chat, and that you put any questions for our speakers in the Q&A box, which is also at the bottom of your screen. Just click on that box and put your questions in that box. Okay? Before we officially start, I have a few thank yous I want to make. First of all, we have some organizations that have helped us to sponsor this series of webinars on Courts Matter to the 2020 elections. And I'd like to thank them. They are Chicago Women Take Action, National Council of Jewish Women, Chicago North Shore and South Cook, National Council of Jewish Women State Policy Committee, Planned Parenthood of Illinois, the American Constitution Society of Illinois, the National Employment Lawyers Association of Illinois, and the Citizen Advocacy Center. We also want to thank the following organizations who are sponsors for today's webinar on voting rights: Reform for Illinois, Promote the Vote Illinois Coalition, and the Rainbow Push Coalition. With that, I'd like to give you a little bit of background on Courts Matter Illinois. Courts Matter Illinois is a diverse coalition of organizations and individuals who are working to ensure a federal judiciary that's comprised of judges who are committed to upholding core constitutional values. Core constitutional values include voting and civil rights, workers' rights, freedom of speech, the separation of church and state, and the right to privacy, among other rights. Here's some of the things that Courts Matter Illinois does. We educate the public and our elected officials about the importance of federal judges who sit on the U.S. District, Circuit, and Supreme Court. We provide information to the community about the judicial nominations process and judicial nominees who will impact our constitutional and other fundamental rights. We support the judicial nomination process that is fair and identifies well-qualified, diverse, and unbiased, nonpartisan nominees. We mobilize our communities to speak out and take action on federal judicial vacancies. Courts Matter Illinois monitors and takes action to ensure fair consideration of federal judicial nominations because the immense power held by the individuals who hold lifetime appointments to seats on the federal bench. And having said that, and knowing that while many of you who are here to hear this webinar understand that process, I'd like to give you a 5-minute overview of what that process is like. And I promise you, it will only take 5 minutes. I think we have to go to the beginning slide. So we're at the end here. So let's go to the beginning slide. This is Federal Courts 101 in 5 minutes. Next slide. This is what the federal courts are made up of: the Supreme Court, the appellate courts, and the U.S. district courts. There are 9 justices who sit on the Supreme Court. We all know about them. But the U.S. appellate courts have 12 circuits and 179 seats. So there are 179 justices there. And the district courts, there are 686 district judgeships. The U.S. Supreme Court hears about 80 to 100 cases a year. They are asked to hear usually about 7,000 cases. So remember that. They hear about 80 of them. And this year they heard less than that. Next slide. Okay, this map will give you an idea of where the federal circuits are. If you look where the number 7 is, that's where Illinois is. We're in the 7th Circuit, and we sit there along with Indiana and Wisconsin. There are only 3 states in our circuit. And if you look to the left of that screen, the federal courts heard 407,000 cases in 218. Remember that the Supreme Court heard less than 100. So think of how many cases are being heard by the federal courts in writ large. Next slide. Okay, this is the way the nomination process for judges to get lifetime appointments to the federal judiciary used to work. When there was a vacancy, the President of the United States would consult with the home state senators in that circuit. Remember that map on the other page, and they would make recommendations. The candidates would be vetted by the White House, and the nomination would be announced based on what the home state senators said and what the White House decided. If the home state senators liked the nominee, they would return a blue piece of paper called a blue slip, and that nomination would go to the Senate Judiciary Committee, and a yes or no vote after a hearing in the Judiciary Committee would be held. And if it was a yes, then that nominee would be sent to the full Senate for a vote. Next slide. Right now, that's not the way this works. Right now, the way it works, when there is a vacancy, the president has been consulting pretty much with the Heritage Foundation and the Federalist Society and other right-wing organizations, not necessarily the home state senators, for nominations. These candidates are vetted by the White House, and then no one is asking home state senators what they think, but they're being brought to the Senate Judiciary Committee for hearings. These hearings are often very rushed, and sometimes they are what we're calling stacked, which means as many as 5 different nominees are heard at the same hearing. That doesn't give senators much time to question the nominees. We've even heard the term rocket docket, which means that's how quickly these nominees are being pushed through their hearings. A yes vote sends the nominee to the Senate for confirmation. Next slide. A number of traditional processes when the nomination comes to the Senate floor have been done away with, and this happened under the Obama administration, not just in the Trump administration, so that there is now very limited time for floor debate or even a filibuster on a nominee that people like or that people don't like. As a matter of fact, the amount of time given for a nominee to be debated on the Senate floor at this point in time is 2 hours. 2 hours for a lifetime appointment. And the majority leader in the Senate can now call for a vote with limited time for debate, and it takes a simple majority to confirm a judge for a lifetime appointment. And with one party holding the majority of the seats in the Senate, most of the votes on these lifetime appointments are often along party lines. Next slide. Today's courts really do not reflect the people they serve. This gives you a sense of what the makeup of the judges, and this is based on 2019 figures in terms of male and female and white and non-white judges. And if you look at this chart, you can see that the judges are predominantly male and predominantly white. I think that our panelists today may be discussing this to some extent in their discussion, but it gives you a sense of does this reflect the people that they are seeing in their courtrooms? And I would think that it does not. Next slide. So what can you do? Well, first of all, we would suggest that you pay attention to these courts. Second, that you raise awareness. Use social media, submit op-eds and letters to the editor, and just talk about this. Tell people what's going on. Thirdly, call your senators and urge them to reject extreme and unqualified nominees. Ask your network, especially those who are not in Illinois and who you know are in other states, to tell their senators not to vote for unqualified nominees. Fourthly, educate others on the importance of the courts, connected to your ongoing work. And lastly, vote. And we're going to talk about voting in this webinar. So there's nothing more important than voting. And that's our Federal Courts 101 summary. So now you know a little about the courts, and now I'm going to let you learn even more about the courts by turning this over to our panelists. And I want to do that by introducing Miriam Judar, who is going to be our moderator for this webinar. So let me give you a little background on Miriam. Miriam, as executive director and community lawyer at the Citizen Advocacy Center in Elmhurst, Illinois. Miriam practices in the arenas of sunshine laws and laws supporting civic engagement. She has empowered dozens of individuals and community groups to use various laws and civic skills to advocate for greater accountability of government entities. Miriam was nominated to the State Legislative Task Force on Civics Education in 2013, which resulted in the passage of legislation bringing civics education back to Illinois high schools as a graduation requirement. Her work with Benedictine University students resulted in amendments to the Illinois Opens Meetings Act to guarantee the public right to speak at public meetings. Miriam has published a report on how the decentralized nature of local electoral boards in Illinois causes systemic barriers to voter access to the ballot and suppresses voices, something we might want to think about as we listen to this webinar. Miriam clerked for the United States Court of Appeals in the Fifth Circuit after graduating from the University of California, Los Angeles School of Law with certificates in public interest law and policy and critical race studies. She is a member of the Illinois and California Bar. She is also a valued member of the steering committee of Courts Matter Illinois. So Miriam, it's my pleasure to turn this over to you to moderate our panel of Courts Matter to Voting Rights. Thank you.
Carol. Good afternoon, everyone. Welcome to our webinar and our presentation today. I would like to introduce our three speakers before we begin. First, Colleen Connell. In January of 2001, Colleen Connell became the first female attorney to lead the American Civil Liberties Union of Illinois. an organization she joined in 1984. Prior to becoming the executive director, Ms. Connell served as the ACLU's Associate Legal Director and Director of the Reproductive Rights Project. In that capacity, she directed the organization's litigation efforts involving constitutional rights of privacy and protecting the rights of Illinois citizens to make decisions concerning reproductive matters and childbearing without undue government restriction. A native of North Dakota, she graduated from North Dakota State University and the University of Iowa School of Law. Alisa Kaplan joined Reform for Illinois in 2018. She was drawn to the organization's long history of fighting for campaign finance reform and against systemic corruption. As executive director, she leads RFI's policy development, advocacy, and educational initiatives, and oversees operations. A Yale graduate with a JD and PhD in political science from Northwestern University, Alisa brings expertise in law and the political process and a background in community organizing, grassroots activism, and nonprofit administration. She has been a faculty lecturer in constitutional law, civil rights, and law and politics at Northwestern, and is co-president of the Board of Open Communities, a Chicago area civil rights and housing justice organization. In her role at RFI, Alisa feels fortunate to be able to spend every day fighting for a more ethical and equitable Illinois government that works not just for the wealthy and well-connected, but for everyone. Gandhi is the senior counsel for voting rights at Chicago Lawyers Committee for Civil Rights, where she leads statewide voter protection efforts. She also advocates for voter access in the criminal justice system and partners with communities of color and low-income communities to reduce barriers to voting and improve civic participation. Welcome, speakers. So let's jump right in. If you don't mind, first of all, just to let the participants understand a little bit about why should they care about this topic. Colleen, want to start?
Yeah, thank you. And thanks everybody for joining this important discussion. Courts matter so much because of our constitutional structure. And, you know, as the Chief Justice Marshall said, 2 centuries ago, it is emphatically the job of the courts to say what the law is and what the law means. And over the course, particularly of the last 60 years, the federal courts have played an increasingly vital role in being explicit about what the individual rights protections in the Constitution, we sometimes group them as sort of the Bill of Rights and the 13th, 14th, 15th, and 19th Amendments to the Constitution, what they really mean for the lives of real people. And the courts matter because essentially in our constitutional structure, they have the last word, for example, on whether the Constitution protects a woman's right to use birth control or to have an abortion. The courts matter because they have the last word on whether the Constitution protects the rights of each of us to decide who we're going to marry, whether it's a person of the same race or the same gender. What the Constitution means with respect to the freedom of speech, religious liberty, due process, and equal protection of law. So the courts are vitally important for defining and protecting our fundamental human rights.
Great, thanks. Alisa or Ami, do you care to comment on why the participants and the public should care about courts' decisions on voting rights?
I can go next. Thank you for having me. It's great to see so many people interested in this topic. I care about this topic because there are so many areas of politics right now that are dominated by the wealthy and the politically powerful. And especially in the wake of Citizens United and other campaign finance decisions by the Supreme Court, this just gets worse year after year after year. And it's very evident in Illinois and across the country. And voting is one of the very few areas now where every American citizen has the same power as every other American citizen, no matter how wealthy they are, no matter how well connected they are, no matter how powerful they are. And that's an essential part of American society that we need to preserve. It's more important now than ever that everyone be able to exercise that power. And it's probably more endangered now than it has been in a generation or more, as I think we'll see as the discussion proceeds. The courts are only one avenue to protect that right, and it can be an important one, as we'll discuss. There are other avenues that maybe we'll touch on here, but we've seen lately that they can do a lot of good and that they can do a lot of damage. So it's important that we discuss their role in all of this. The last point I want to make is that voting is changing right now. And we see that, and with COVID, it's changing faster than we probably ever thought it was going to. There are all kinds of paradigm shifts in voting by mail and in centralizing voting processes. And that's going to create a whole other range of challenges that courts and state legislatures and the national government are going to have to face. So we really need to be more attentive now than ever to what's going on in this area.
Thanks. Ami.
Hey, good afternoon, everyone. Thank you so much for having me. It's really great to be in conversation, especially with colleagues who I know and have the honor to get to work with on various issues over the years. So thank you very much for the opportunity. I wanted to share with you a little bit about why I care about this topic. I came to the field of public interest law about 10, 11 years ago. And at that time, I was really focusing on immigrants' rights. And within that, some aspects of voting rights, including working to strengthen language access to the polls, advocating for communities of color in the redistricting process. That it's actually through that I got I had the good fortune to get to meet Miriam and start collaborating with her and learning from her work. I found myself that the more I was working on issues that affected people in my community, in the Asian American and South Asian community, and in a diversity of immigrant communities, time and time again, I was reminded of more fundamental civil rights conversations and really tough battles for voting rights in the Black community and in by other civil rights pioneers who paved the way for people like my family to be able to be in this country, and for someone like me to be able to exercise my right to vote. I've been really privileged for the last few years to work at Chicago Lawyers Committee for Civil Rights. And nowadays, the voter protection work that I have the opportunity to do, the highlight for me has been working with community members in the criminal justice system. My voter protection work and voting rights policy work in jail and prison has really been the highlight for me, and when it hits home the most to me in terms of the importance of the right to vote. It's also the aspect of civil rights and voting rights work that has been the most reshaped in the recent months since we all started having to stay at home, and since both the health conditions and really the civic engagement conditions in correctional facilities is really, really concerning on many levels. So these are some of the reasons that I see in my community and in others that I have the privilege of working with, why voting rights and access to civic engagement matter so much. And as Alisa and others have shared, that is sometimes determined by the courts. And at the end of the day, in a variety of our communities, we see that voter access affects voter turnout. And so when a court decides that voter access can be expanded, or when the court curtails it in some way, I've seen the direct impact that has on who feels compelled to or comfortable with going to a polling place. So thanks again for having me.
Yeah, thank you. All right, well, thanks for your answers. So given that the federal judiciary is instrumental in protecting individual rights, that in the arena of voting, it could play a really big part in that leveling the playing field, because voting, as you said, Alisa, is something everyone shares in and shares equally or ideally. And given the impact really that voting has for everybody, if everyone would participate, if voter access was better. Let's take a look at some of the significant federal cases on this topic. And there's cases, you know, that run through a broad spectrum of election issues that affect voting, like gerrymandering, for example. So why don't we start with that? I think most of our participants have probably heard about Shelby v. Holder. Why don't we start there? Will one of the speakers like to begin? To give us some background on Shelby and how it's affected?
I can start briefly on that, but please, Ami and Alisa, jump in. Shelby County presented to the Supreme Court the question of whether one of the provisions of the Voting Rights Act of 1965, as renewed by Congress a number of times, including recently in the 20th century, whether the formula for basically deciding which states and which jurisdictions had to pre-clear changes in their voting laws had to be run through either the U.S. Department of Justice Voting Rights Division or a three-judge federal court, was, too broad an exercise of Congress's power under Section 2 of the 15th Amendment. And the court, unfortunately, said, yes, Congress exceeded its power, and basically the pre-clearance requirement, or the formula for deciding pre-clearance, was no longer needed. The impact of Shelby County, in a word, has been disastrous in terms of access to the right to vote. And I just want to underscore how absolutely spot on Ami is when she says access really does determine, in many instances, voter participation and voter turnout. And the reason that the Voting Rights Act has often been described as the most important civil rights legislation that the U.S. Congress has ever passed is because of what the Voting Rights Act meant to increase access and increase voter turnout, particularly in the South, the old states of the old Confederacy, for people of color, primarily, but not exclusively, Black American. And the Voting Rights Act had allowed both the U.S. Department of Justice and a number of other civil rights and civil liberties groups, including the American Civil Liberties Union, the NAACP, Legal Education Fund, Common Cause, to challenge, by and large, Southern voting laws that restricted access and restricted the ability of people to vote. The court, and I'm paraphrasing and oversimplifying, in Shelby County, basically concluded that there wasn't really a need for this pre-clearance formula, given the fact that the very turnout and increased participation of Black Americans in voting in the South meant that the Voting Rights Act had served its purpose, and there was no longer any need for its protections. Nothing, of course, could be further from the truth, because since Shelby County, we've seen an explosion of the number of voting restrictions that have been proposed and acted into law in primarily, but not exclusively, the states of the old Confederacy. I just want to point out real quickly that the Voting Rights Act and the pre-clearance requirement is not limited to the states of the old Confederacy. There are certain districts in northern states that have a history of voter suppression, and there are particularly a number of jurisdictions, particularly in the western states, that have a sordid history of discriminating against voting rights in the indigenous or Native American populations in this country. And those districts have also been subject to the jurisdiction of the Voting Rights Act. And so all of a sudden, post Shelby County, we have had the most important voting rights protections, I think, quite frankly, compromised.
Mm-hmm. Right. So given that Shelby struck such a huge blow to voter access, I think almost immediately we saw legislatures passing bills to restrict people's the flow towards voter registration and voting and the ease of access there. So why don't we turn to some of the significant cases that arose from those kinds of bills? Amir, Alisa, where should we start? Voter ID, voter registration, your pick.
Ami, why don't you take this one?
Sure. I'm happy to start off with some of the cases that I have in my mind that have made an impact, particularly for Illinois and Midwest voters, and that affect the Seventh Circuit law that can influence our voting rights here in Illinois. So to back up a little bit from even before talking about specific cases, I wanted to mention as a backdrop that even in Illinois and even today in the year 2020, unfortunately, there are still concerning voter registration disparities for Black, Latino, and Asian American voters. A bureaucratic requirement like voter registration should not in this day and age be making an impact on which groups of citizens get to vote. And yet we see that advocates and communities still have to fight hard to have equitable access to voter registration. One example that comes to mind of a case that addressed this was the federal court challenge to the Illinois Election Day registration law. Now, this was a suit filed by the Liberties Justice Center weeks before the 2016 presidential election, and it challenged the state's legal requirement that Election Day registration must be available in all polling places in all counties in Illinois, and in some counties in all polling places. And the law was challenged, the state law was challenged on equal protection grounds. Thankfully, after a lot of back and forth, procedural back and forth in the courts, the Seventh Circuit Court of Appeals held that Election Day registration could go forward for the 2016 election. But unfortunately, that late in the game, a lot of voters were confused. And it definitely was not just a given that the courts would uphold this really important program for eligible voters in Illinois. We had the chance to advocate with the ACLU of Illinois and others in this seminar today as amicus parties to try to argue to the court that voters' rights must be respected and Election Day registration must be upheld. Fast forwarding a bit, because again, as I mentioned, we still have voter registration access disparities in Illinois. The Just Democracy Coalition, a group of nonpartisan voting rights advocates in Illinois, filed suit earlier this year challenging the state of Illinois' delayed and flawed implementation of automatic voter registration. This is a state law that was signed 3 years ago. It was championed as a bipartisan initiative. It had unanimous bipartisan support in our state legislature. And yet the state has been dragging its feet and in implementation and unfortunately incorrectly implementing several aspects of the law, which has led to real harm experienced by voters and community members. In our suit, we were privileged to represent the coalition members in that suit, and we allege violations of various federal laws like the National Voter Registration Act, the Federal Voting Rights Act, and the state's law, the state's AVR law. Just Democracy filed suit reluctantly, actually slightly before the pandemic was really deeply affecting Illinois and Chicago, and we've repeatedly publicly stated, and I'll say it again here, that we really hope to reach a resolution here with the state of Illinois. You know, courts are not always the way to go when it comes to enforcing or expanding or protecting voting rights. That's certainly the case in Illinois. Sometimes there really can be a lot more progress from working collaboratively with government agencies, and we're not going to hold out. We're not going to lose hope yet, and we're still going to hold out hope that even that could be possible with a pending case, pending voting rights case in the courts now. But the courts certainly are an important mechanism if community members feel like they have no other choice in order to protect their rights. Really briefly, I do want to mention a couple very recently filed cases in Indiana federal courts. So Indiana is part of the Seventh Circuit as well. Indiana is also my home state. And so keep in mind that you know, I grew up in Indiana, so when I say really negative things about the voter restrictions in Indiana, I'm not trying to poke fun at people there or anything like that. But it is extremely concerning, just one after another voting rights restriction that has been enacted by the Indiana State Legislature. So there are a couple cases that Chicago Lawyers Committee for Civil Rights recently filed. One is challenging the state law in Indiana that limits voters' ability to go to state court on election day if they want to argue that a polling place should be kept open late. If, for example, they want to argue that polling place hours should be extended because the polling place did not open correctly in the morning, or because of some other circumstance certainly outside of the voters' control, why they couldn't get to the polls in time. And so that's state law that we're challenging in a federal case right now on behalf of Common Cause Indiana. And then another recently filed case of ours is on behalf of Common Cause Indiana and NAACP Indiana State Conference. And that is challenging the Indiana law's unreasonably early ballot receipt deadline. So the Indiana state law says that absentee ballots must be received by the election authority by noon on election day in order to be counted, even if it was postmarked a while back, and even if it was because of U.S. Postal Service delays, you know, really beyond a voter's control of why the ballot didn't get delivered to the election authority on time. Especially as more and more community members need access to absentee voting or mail-in voting, our clients found it, you know, completely unacceptable that many of their community members, their votes could just get thrown out because of a postal service delay that, you know, we certainly anticipate this year. So I'll turn it over to Alisa. But thanks for the opportunity to share some of what we've been hearing from especially voters of color about the legal fights that they're interested in.
Thanks, Ami. Before I talk about some cases, I just want to come back to Shelby for a second and talk about some of the downstream effects of that case, which eliminated pre-clearance. So as Colleen mentioned, in the immediate aftermath of that case, several states immediately started passing restrictive rules that they would not, voting rules that they would not have been able to pass had they had to go through the pre-clearance process. So the same restrictions that had been turned down by the federal government previously, they immediately passed. And North Carolina and Texas were the first two states to do this, with restrictions on early voting, voting registration, photo ID, things like that. And a lot of these restrictions were later struck down, particularly in North Carolina or by Texas courts, were later struck down as discriminatory. In fact, a Virginia judge in the Fourth Circuit said that in North Carolina, they had targeted minority voters with, quote, surgical precision. So these restrictions were found to be unconstitutional and invalidated. But unfortunately, that process took years to go through. Unlike with pre-clearance, where they would have stopped them immediately. And so people would have been able to vote in the numbers and in the ways that they had been voting before. And the cost of that delay is that in the meantime, you have elected officials and state judges, in many cases, who are elected under discriminatory rules that were later found to be discriminatory. And so those people were not necessarily elected by an accurate reflection of the voter population. They were elected by the segments of the voter population that those state legislators wanted to amplify, if that makes sense. And so this is a way that Shelby helped entrench political power and helped entrench these discriminatory practices, because now these state legislators, these Supreme Court, these state court judges can keep passing restrictive rules. And so it's a really harmful just cascade of effects that has flowed from Shelby that we need to pay attention to going forward. And for anybody who says, well, it wasn't important that, you know, we can still go through the court process. No, that's a huge cost of having to go through the court process, is you end up with a distorted elective political system. Just to go on to a few recent cases that some people are probably familiar with or had heard about. These are COVID era cases, and we don't have a lot of, they don't have precedential value for the most part, at least in the Supreme Court level, because they were mostly emergency orders where the Supreme Court sent them back to lower courts. But they send a really troubling signal about the willingness of the Supreme Court to step in to expand voting rights and voting access, and actually really kind of project a disturbing desire to constrict voting rights as much as possible. So a couple of these cases, and I think that even though they're COVID era, they probably say something again as we go forward with modernizing our voting system and get into more mail-in voting and consolidated centralized voting and things like that. So in Alabama, lower federal courts found that an Alabama law, Alabama required, if you wanted to send in a mail-in ballot, either 2 witnesses had to witness you signing it, or you could get a notary, or you had to include a copy of a photo ID. And suit was brought saying that this was unduly burdensome in the age of COVID, because you'd have to, you know, violate social distancing rules. You'd have to go out, you know, if you didn't have a Xerox machine at home, you'd have to go out and find a way to photocopy your photo ID. Of course, there's a separate question of whether everybody has photo ID. And so a lower court said that under COVID, that was an unreasonable burden on your ability to vote, and carved out some exceptions for people who were susceptible to COVID or people who were over 65. And the appellate court allowed that order to go forward, you know, basically said, we agree with the lower court for the time being. And the Supreme Court stepped in, and against those 2 lower courts, blocked that order and basically restored those restrictions in Alabama. So even though, again, this is a temporary order, they said, you know, this is just temporary until it goes through the appeals process. That was a disturbing case where really they could have just let the lower courts make that decision and expand people's access to the vote in this time. Similar case out of Texas, where people of all, there was a rule that to vote by mail, you had to be 65 or over or have some medical conditions. And there was a suit filed, I believe the ACLU was involved in this too, to allow everybody to vote. They said, you know, if people over 18 have the right to vote, they should have the right to vote by mail. A lower court made that order. And the Supreme Court, again, stepped in and blocked it. So you have these 2 cases where the Supreme Court almost seems to go out of its way to restrict voting rights. The case that everybody's familiar with in Wisconsin, where a lower court tried to extend the absentee voting deadline because of COVID. Again, the Supreme Court came in and said, you can't do that. So we've just had a spate of cases that really don't bode well for the expansion of voting rights in this new era coming from the Supreme Court. And I think it's important to note that in many of these cases, the Supreme Court is coming out to be more restrictive on voting rights than the lower courts. And so what accounts for that? You know, maybe it's that it's easier to politicize the small membership. A few different changes on the Supreme Court can make a huge difference, whereas the lower courts are more decentralized. But you see increasingly this troubling trend.
All right. Well, and there are more cases that are listed on the Why Courts Matter to Voting Rights one pager that I believe all of you have access to. So if you have questions about those cases, please let us know. But let's move on. And you know, earlier we took a look at the, how the federal judiciary is comprised. And we know that it's no secret that this administration has appointed at a faster rate than ever before the federal judges at a huge pace, fast pace. So we've got 200 new judges on the federal judiciary, and most of them, if not all of them, I think are white males. So the administration isn't really looking at minorities, people of color, women, and other groups that lack representation on the court. So taking a look at these cases and then other cases that are pertinent that we haven't had time to talk about, can any of you identify any trends in the courts with respect to voting rights that we can identify generally speaking? Maybe not, and if not generally in the nation, like in regions, or within the different topic areas in the broader category of voting rights? Any themes or anything that we should expect with this changeover in the federal judiciary with a more conservative judiciary?
Oh, Miriam, just a couple of trends that I unfortunately am seeing, and this really builds on what Alisa was saying. I think that we have seen an increased tendency by the federal courts, mostly, by the Supreme Court, but also we're seeing it creep into the decisions of the Fifth Circuit, Texas, Louisiana, the 11th Circuit, Florida, Georgia, trying to recall Carol's wonderful map, and to some degree the Fourth Circuit as well, Court of Appeals, of upholding rather than striking down the restrictions on voting that were passed by the various state legislatures. And just again, to build on the Shelby County case, the value of the pre-clearance requirement, and I wasn't really that clear about it, was that any real change in a covered jurisdiction's voting rights had to be pre-cleared and pre-approved by the Department of Justice or this lower pre-judge federal court. And the consequence of that really was that, to go all lawyerly on people, was that the state that had enacted the changed voting requirement had the burden of showing that changed voting requirement would not have a discriminatory or disparate impact on protected classes of voters, primarily minority voters. And now really, the burden is reversed. I mean, it's almost like these laws are presumed to be okay. And there's like a very high showing, factual showing, that the organizations like the ACLU, like the Lawyers Committee, have to show before they can persuade a federal court that the law is unconstitutional. And so that's one trend. It's just harder to win in court than it used to be, because the kind of factual showing that you have to make is so large. And the second trend that I think is developing is it's the willingness of the federal courts to give the more political branches the benefit of the doubt and to say that something is beyond the jurisdiction or beyond the appropriate area of consideration by the federal court. So 2 terms ago, the Supreme Court had in front of it 2 political gerrymandering cases. And so a little bit of background here. For many years, the cases had come up to the court in which one party or the other, Democrats or Republicans, were alleged to have drawn the redistricting lines in a way that favored their voters, their partisan voters, and disfavored the other organization. And the 2 cases that came up to the Supreme Court involved redistricting in Wisconsin and redistricting in Maryland. In the Wisconsin case, the redistricting was alleged to have really benefited the Republican Party. Something like, when you looked at the voting results, I think this was for 2016, Democrats, 51% of the candidates received votes by Democratic voters. And yet, this is the state legislature, the way in which the district lines were drawn meant that Republicans, even though they lost essentially the state version of the popular vote, came away with 2/3 of the legislative seats because of the way in which the district lines had been drawn. In Maryland, the situation was reversed, not quite as dramatically. But even though Republicans had garnered the majority of, the Republican candidates had garnered the majority of votes, Democratic candidates won a majority of the seats in the state legislature, again, because of the way the district lines were drawn. And so fast forward, it was litigated in the lower courts. In both cases, the lower courts had found, a violation, of the law. It gets to the Supreme Court, and the Supreme Court takes a pass, which really was a decision under the guise of no decision. And the court said basically, these questions of partisan gerrymandering are too political. They're beyond the area of expertise of the court to decide. And so if the voters want recourse, vote these people out of office. And you want to say, aren't you paying attention? Aren't you reading the briefs? Because that's exactly what the voters tried to do. But because of the way the district lines were drawn, the will of the voters were, quite frankly, disregarded. They were suppressed. And so, the tendency of the courts to not decide cases in which, sort of the democratic interest would prevail, leaves in place a very ugly and increasingly ugly status quo in terms of equal protection of the law and voting access and voting rights more generally. So that's sort of a second trend that I, have, sort of noticed. And I think that it's very, very, scary when we think about the stakes of the 2020 election, for example.
Thank you for that. Is there better news on the horizon? Do you all agree with that, Alisa and Ami?
Yeah, ironically, one of the most famous cases for deciding what issues are justiciable, what issues a court can decide, was a gerrymandering case back in 1962. And so this is really, we've seen a progressive, what I would view as an abdication of the court's responsibility to step foot into this area where, as Colleen said, voters really don't have the ability to remedy this situation when their political power has been so diluted by these gerrymandering rules.
Yes, Colleen.
Yeah, if I can just sort of expand on what Alisa just said briefly. I mean, one of the other matters that's working its way through the courts, and it's been up and down, but it connects with one of the most recent awful developments by the Trump administration. And that development has been sort of the directive that census workers should not count undocumented people. It's, I think, one of the, additional efforts not to count everybody, regardless of their immigration status in the census. A case that came out of Texas a few years ago raised the question of whether, in deciding whether redistricting lines or redistricting was, consistent with both the Voting Rights Act and the Constitution, was the question of whether, in trying to draw districts that approximated each other in population, which has basically been sort of the rule of law since the 1962 case that Alisa mentioned of Baker versus Carr and its predecessor, Reynolds versus Sims, which distills to one person, one vote, and so we've really tried to draw legislative districts, of about the same number of people in them. One of the questions that came up in the Texas case was whether the number of people meant the number of people writ large, everybody in the district, or whether it only meant voting age population. And the Supreme Court ultimately did not decide that question. But one of the moves by both anti-immigrant activists, as well as one of the moves by, I think, the forces that would deny, voter access and, more equal representation in terms of how we draw our voting or district line, has really been to focus on voting age population, because that favors the more rural districts that are older in population, that have voting, older voters, over and above more populated urban areas, which have a higher number, for example, of children, not voting age population, and may have a higher number of, lawful permanent residents, green card holders in common vernacular, or undocumented people. And so you can see where that trend would be going in terms of, sort of equal representation of one person, or every person's vote, or every person being equally represented, were that trend to continue. And, I think that that's one of the issues that is going to come back in front of the court and the Supreme Court. And that's why courts really matter, and why, voting for candidates who take seriously the importance of the federal court in defining and protecting constitutional rights is such an important decision for voters to make.
Thank you. So it's, it's a sad commentary when an issue of when the principle of one person, one vote, which was such a sacrosanct principle, is also being attacked. And taking a look at, listening to what you all are telling us about what's happening across the country, I'm struck by the fact that individuals across the country are all going to have different experiences, whether what state they're from, and then what their local election authority is prescribing for them for their voter experience. Can any of you speak to the on-the-ground impacts of these court decisions, whether in gerrymandering, with voter purges, mail-in ballots, polling places, what have you? What are the on-the-ground impacts, and particularly with respect to marginalizing groups and further marginalizing marginalized groups?
We've seen in research time and time again that problems like overly long lines at a polling places opening late in the morning, or absentee ballots getting thrown out for unnecessary technicalities. The list goes on and on, but we've seen that those types of issues relating to voting disproportionately impact voters of color. and Black voters in particular, and in some instances, other communities of color as well. It's not always feasible to bring or win a court challenge for all the reasons that we've been discussing today. And so that can just exacerbate the problem for voters who actually have experienced something that legally should not be tolerated, but don't really have a realistic mechanism to have their rights enforced. But, you know, it's worth backing up and remembering that the courts are certainly not the only culprit here for perpetuating these negative impacts on voters of color. These sorts of disparities are not new. Our voting systems, and even something that might sound as innocuous as a voter registration system, they were set up in the first place historically to cement the power of particular people, to exclude particular people from the electorate. I mean, there's a lot of historical research showing that voter registration systems were set up in Illinois and other parts of the country specifically to exclude formerly enslaved community members, to exclude immigrant citizens who were mistrusted, and low-income community members from all racial backgrounds. And so, you know, when that's the origin of some of our systems, then even things that might sound like not a big deal, like a bureaucratic requirement of voting or registration or polling place access, it can just make the effects all the worse for marginalized communities, and sometimes make the barriers harder to detect and really excavate and just do away with completely. We've seen that the effect on first-time voters can be particularly pronounced for these different kinds of voter access barriers, and that's something scary to me in 2020 especially. But, you know, in addition to communities of color, young people, formerly incarcerated community members, for a variety of reasons that I may, in my own life experience, I may relate to it or not relate to it, but there can be a lot of reasons why someone has not voted before. And if they're a first-time voter in 2020, there are a lot of barriers that could be really tough for people in that situation. And what I'm also concerned about is that those first-time voters, their inexperience could be blamed, even though we say we don't believe in literacy tests anymore in our country, or we say that voting should be available for anyone who's a citizen and who's old enough. We still end up in effectively excluding certain people from the system through these court decisions and through these other decisions about voter access.
Hence, there's long-term effects. Does anyone else want to comment on this topic, this subtopic?
I want to amplify what Ami said. I agree with everything she said. And there is empirical data about how these rules impact particularly minority populations. I think it's important to note that they also disproportionately impact people with disabilities, especially things like polling place closures make it that much more difficult for people with disabilities to access them. And actually less than half of polling places in the country are considered fully accessible to that community. And so that's an ongoing issue that, that is really tied in with all of these different issues. I also want to say that it's hard sometimes, you know, a lot of people want to look at turnout of different communities to see how these things are impacting them. And that's not, it's very hard to use that as a metric all the time because turnout is so affected by race particularities. But we've seen, you know, there's litanies of horror stories about people, for example, and one of the plaintiffs in one of these cases was an elderly woman trying to get a photo ID. She had to go to 11 different state agencies, you know, to try to find her birth certificate, to, you know, get her documents in order to get everything corrected. And of course that's a cost, and how does she get there? And, you know, all of these different things that people particularly in vulnerable communities, these hoops that they're expected to jump through. And I want to just highlight sort of the psychological factor involved in that even if people do manage to get all of that together and vote. And we know that many people are deterred by those barriers. What does that mean to someone when their government, the entity that's supposed to be protecting them and help them exercise their voice and their franchise through voting, is putting all of these barriers in their way? And it's, you know, clear often that it's because of the color of their skin or because of their, you know, all of these different factors that we're talking about. And I think that's an important thing that we need to think about when we're talking about all of these and the impact on different communities.
Well, if no one has anything else to say on this topic, let's move on to talk about like possible solutions. And I know that diversity is often invoked as a measure to help to protect individual rights, stronger protection for individual rights, for example. So can you all comment on why, a little bit more in detail, why diversity is important on the federal bench and why the general public should care about diversity in the federal judiciary?
Go ahead, Colleen.
So, you know, I think diversity is important in every sense, but I want to add just the obvious that the color of one's skin does not necessarily make you a human rights advocate, and I think we need look no further than Justice Clarence Thomas on that. And I think that one of the most disturbing things about the Trump administration goes back to one of the slides in Carol's presentation, contrasting the way the process used to work to nominate and then get confirmed judicial appointments, and the way the Trump administration is doing it, which is basically consulting with the Federalist Society and the Heritage Foundation. There's no ideological diversity either on the court. Instead, what we have seen is the growing imposition of a litmus test, and it's no longer the litmus test, or solely the litmus test of 20 years ago, of whether the nominee would vote to overrule Roe versus Wade. We've increasingly seen judicial nominees from the Trump administration that will not say whether they think Brown versus Board of Education was rightly decided. And we've seen, questions about whether a Obergefell, which involves the right to marriage equality, was rightly decided. And so I think that, diversity on the court is hugely important because I think it, underscores the point that Alisa was making with respect to, the harms on the ground of these voting restrictions, which is it makes people feel that they don't belong, that they're not welcome at the civic, in the civic conversation, in the civic discussion, in our civic life. And, and I think that, just to put some more concrete application on it, I think the fact, for example, that we now have 3 women justices on the court has been hugely significant in terms of, excuse me, how the court actually really examines, the impact of laws that are alleged to have a disparate impact on, women or discriminate against women. And I think it just underscores what we all experience in our personal lives. When you are in day-to-day contact with somebody who's different than you, you are exposed to perspectives and viewpoints that are different than yours, and you see that something that doesn't affect you, and so why would you think it was unlawful or unconstitutional, has a very different impact on a person of color, or a very different impact on somebody who's a member of the LGBTQ community or a woman. And so I think it's just hugely important that, our federal courts, our state courts too, reflect, the huge diversity in this country, because that diversity actually affects how, how people are able to exercise their rights that are ostensibly protected by the Constitution for all of us.
Yes, so divergent life experiences are definitely the kind of diversity that could help us get more thoughtful written decisions that consider many forms of experiences or many types of experiences. Is there anything else that the other speakers would like to comment on diversity and its importance to the federal judiciary and why we should care?
Yeah, it can matter at all levels of the courts is one thing that I want to add. I mean, I really agree with all these very helpful insights from my colleagues here. Our clients in voting rights cases feel, even at the district court level, feel like things depend entirely too much on the luck of the draw. I mean, that's unsettling and it's strange. And I can't even totally wrap my mind around it at times, that we're talking about the same law here, whether this judge gets assigned this case or this judge gets assigned the case. It shouldn't be a radically different result depending on, which political party ended up having control of that appointment. Voting rights cases can be very quickly moving. I'm definitely noticing that this year because of the Purcell precedent and for other reasons, that there's just a lot of pressure that if there's anything that voting rights advocates want to get achieved through the courts, and they have to be prepared for a case to move really quickly. And decisions like a briefing schedule and what rules need to be clarified for voters by what timeline, those kind of decisions that district court judges and magistrate judges make can have a very concrete impact on voters. It can make the difference between whether someone has the right to vote or not, whether someone thinks they have the right to vote or not, which, as Alisa and Colleen have talked about, that carrying that load and someone not being sure if their vote is going to be counted or if they have what it takes to get through the complicated voter registration or voter ID process, that can be the difference for people, especially in times like this, of whether they want to go through the effort of trying to vote or not.
Thanks.
Yeah, I totally, I agree that there's basically two things, right? The legitimacy of the court and the courts, and that they look like the people that they're serving, and the quality of the decisions, right? That should reflect a diverse range of experiences. I do, while we're talking about troubling trends, just want to highlight the extremely troubling trend of the difference in appointments between this administration and the previous administration. So we were actually making pretty good inroads into creating a more diverse court system, federal court system. Under Obama, about 18% of his appointments were of African-American judges, about 10% of Latinx were Latinx judges, and about 40% were women. Under Trump, it's 4% African-American, so that's 18-4. It's 4% Latinx, so that's 10% to 4, and it's 24% women, so that's 40 something percent to 24. And so, and he's made 200 appointments already. So this is going to have a lasting impact on the diversity of the bench in a way that I don't think any of us would like to see.
Thanks. So before we move on to questions and answers and a wrap up, I want to end on a positive note about what can the public do to help the situation? Or if they want to make an impact in this arena, what options are available to them?
So Mary, first of all, I'm going to say they can educate themselves, and a huge shout out to your work to reinstall the civics education requirement as a condition of graduating from high school. The fact that people don't know how important citizen participation is at all levels of our democracy. is I think one of the reasons that we've had, you know, such low voter turnout, and we've had, you know, I think the you know, the amplification of the importance and the impact of money in politics. And so I think the first thing that people can really do is to get involved and to make sure that their children and their family members, you know, get involved. And I want to go back to something that, you know, that Ami said, you know, earlier in terms of voter protection efforts. Support organizations like the Lawyers Committee that does great voter protection work. And also think about voting. I mean, there's a lot of research out there that suggests that people who develop a plan on how they're going to vote have much higher voter turnout rates than people who don't have a plan. And that may seem just formulaic to some of us who are longtime voters and, you know, who came from families who are longtime voters. But it's really important, particularly for younger voters or newer voters. There's also a fair amount of research, you know, that citizens who are maybe first generation, natural born citizens here don't have as high a voter turnout sometimes because their parents didn't actually feel a part of and didn't vote in the election. So I think that, you know, really embrace, you know, everybody on this call, please embrace the importance of voting rights and voter turnout and voter participation as a key part of civic engagement and a key part of making sure that our judiciary does its constitutionally defined job of protecting rights for all of us. I mean, our constitutional structure vests that power in the federal courts. And unless we participate in the political processes of voting for members of Congress, members of the Senate, and the presidency, we are not just giving up our ability to influence that judicial selection, but we're quite frankly, I think, abdicating our rights, our obligations as citizens.
Ami, Alisa, what can people do in addition to the wonderful suggestions Colleen gave us about educating yourself, educating your family, voting?
I hope that people feel free to call us anytime. We have a voter protection hotline, 866-OUR-VOTE, 866-OUR-VOTE. We have companion lines for community members who speak languages other than English. We answer those calls live as it gets closer to election day and on election day, of course. And then before that, people may get referred to voicemail and then we would call you back. So no question is too small or silly or minor or anything like that. You know, any questions that voters have about the process or any problems they're experiencing, we're happy to answer. Thank you, Colleen, for the plug about that as well. And thank you for your ongoing support. I didn't mention this earlier to all, but in addition to working at Chicago Lawyers Committee, I'm a proud board member of ACLU of Illinois. And I really appreciate that all of us advocates, you know, across all of our organizations are finding ways to play complementary roles during these really important times.
Alisa.
So dealing with federal courts and talking about federal courts can be really frustrating because it seems like this really undemocratic thing that we have no control over because these judges are lifetime appointments and we don't get to hold them accountable through our vote. But as Colleen mentioned, they are appointed through a political process. So our involvement in federal elections, it leads directly to the composition of the court. And so we need to stay engaged in these issues at the electoral politics level. I also really want to emphasize, and I spend a lot of my life in my role doing this, the importance of your state politics. All of these restrictive rules that we're talking about have been passed by state legislatures and often state courts have a really essential role to play in protecting voting rights, both in protecting them under the US Constitution and in many cases in protecting them under their own state constitutions. Actually, many states have more protections in their state constitutions than the federal constitution has for voting rights. So it's really important to stay engaged. I know a lot of us tend to tune out with the state and local judicial elections. It's really important to stay engaged as much as possible in those, and to stay engaged with your state legislative, elections as well, and what's going on there. So many people neglect their states and their local representatives. And really, they are the front line on election protection. Mm-hmm. So we have more control over this issue than we think, and it's just up to us to exercise it.
Thanks, Alisa.
So thank you all. We have one question based on some of our earlier discussion, asking if there was a remedy for judges elected as a result of a discriminated population. I think it went back to your gerrymandering question. And when we were discussing the gerrymandered election.
Right, and under Shelby with
people. Are there any remedies?
Not that I'm familiar with. There are no remedies that I'm familiar with state legislators or local officials who are elected under more discriminatory rules. It's just try to fix those rules and vote them out the next time.
Yeah, and we should point out that federal judges are appointed and the state judges are elected. So we care about diversity and representative judges both on the state judiciary as well as the federal judiciary, of course.
Right. And it is rare, even with elected judges, to see them. We're starting to see some monitoring there on those judges that are elected at the state level, but it's a long process. You're on mute, Colleen.
You're on mute, yes.
Thanks, sorry. I want to just add one more thing in terms of, is there a solution? And this is to really urge people to turn out to vote regardless of the access restrictions, because even in gerrymandered districts, if everybody turned out to vote, that in many cases would affect the outcome. And so, I think it just, it adds to the burden. Everybody needs to turn out to vote. And I think that we need to, urge everyone to, vote early if they're in a state that allows early voting. We need to really urge people to persevere through, if they can, through restrictions on access. And again, go back and really have a plan, because even in gerrymandered districts, even in districts that, we're drawn to, pack as many possible voters of a certain partisan, party into one district and as few in the other. It is still possible to win the day if everybody shows up. Everybody shows up to vote. And the other thing I would really say is, I think that we all have an obligation to be truth tellers, and we should not leave unchallenged the lies that are being told about voter fraud, including allegations of unverified and untrue claims of voter fraud by people who aren't citizens. I mean, or people using the mail to commit voter fraud. Voter fraud is almost non-existent in this country. It's just not something, that people do. Nobody wakes up and says, oh, I want to go defraud, the voters, the state by, voting 10 times, or by, claiming I live somewhere where I don't. And so I think that we, as citizens, because politicians read the newspaper, when you see, these false claims, say, I've been a voter for so many years. I've never seen the kind of behavior that's being alleged because people do read the newspapers. And so I think we all have an obligation to be truth tellers as well as good civic participants in the electoral process.
Well, we are just about out of time. I want to remind everyone that we have developed a one-page fact sheet on Courts Matter to Voting Rights. It's on our Facebook page and it's available to anyone. We have them on each one of these one-pagers for each of our webinars. So we hope you'll download it because it talks about some of the cases we've discussed. It talks about key points. It gives you questions you can ask candidates who are running for office, and it gives you some information about why courts matter. So in closing, I want to start by thanking our panelists for their wisdom and their insights today. I want to thank Colleen Connell from the ACLU of Illinois. I want to thank Gandhi from the Chicago Lawyers Committee for Civil Rights. And I want to thank Alisa Kaplan from Reform for Illinois. I especially want to thank Miriam Judar from who has been our very able moderator and my good friend. And behind that sort of label that says Courts Matter Illinois is Mike Vaya, our Courts Matter outreach coordinator, who's been helping things to run very smoothly today. Thank you, Mike. Second, I want to again thank all of our sponsoring organizations and especially the organizations who helped to sponsor today's webinar. We thank you for doing outreach to your constituents and getting people to join us today. And third, I want to thank all of you who joined us today for your participation. I want to remind you that our fourth webinar, Courts Matter to Climate Change and the Environment, will take place at noon on Tuesday, August 25th. We hope you'll join us for that one as well. Information about registration for that will be out soon. We hope that you will also join our Courts Matter family and advocate for a fair and just federal judiciary. You can check out our Facebook page or email us at courtsmatterillinois@gmail.com. Please remember that courts do matter, and please vote. Thank you all, and I hope you have a great afternoon. And I do have one more point. It was pointed out to me that our president has actually today changed his mind about mail-in voting. What?
In Florida.
In Florida, apparently. So miracles do happen, at least partially. So I hope you all have a great afternoon. Remember to vote and remember that courts matter. Thank you for joining us.